Njoku. So Emmanuel Sang, Anthony Wangombe, and Joshua Keter be detained at the Naivasha police station for a period of 21 days. He has sought this period in order to conclude investigations. His application is on the grounds laid on the face of the application of the affidavit in support of sworn on the 31st of October. Now, I do not need to read everything, but Koprolo took oath and stated preliminary investigations into the murder of a police officer, the deceased Hassan Lol Kidid, show that the deceased and the four suspects, all police officers, were responding to a crime scene at Msikitini area within Maimahiu. There they found a lorry, registration number KDU 614G, Isuzu FRR. They found loaders offloading stuff from the lorry, including hardware items and tires. Somehow the offloaders, numbering slightly over 10, dispersed and scattered. All the officers, including the deceased, were armed. Somehow the deceased was shot in the chest and he succumbed on the spot. Koplo Orwa is investigating the murder of the officer. He believes that the four suspects have something to do with it. He stated that the lorry KDU 614G Isuzu FRR has been reportedly hijacked and the driver kidnapped. The information coming his way is that the vehicle was driven to the scene by people believed to be police officers. The driver of the lorry has not been traced. When he visited the scene shortly after the reported incident of the shooting of the deceased, he stated that he found the scene disturbed. In his view, it appeared choreographed to show that the deceased had shot himself in the chest. He confiscated all the pistols held by the four suspects and has forwarded the same for ballistic examination. There is a bullet lodged in the chest of the deceased. He would also like post-mortem to be conducted so that the bullet can be retrieved and the same analyzed. He seeks 21 days in order to ensure that he is able to reach all witnesses, who include informers of the four suspects. The crux of his application appears to be apprehension that the four suspects may interfere with witnesses and the ongoing investigations. He believes that the four are behind the hijacking and robbery incident involving the lorry. The loaders and others know that. He wants to reach them and record statements and obtain crucial leads. He also indicated that there is a loose weapon still at large and which poses a danger to the community and will likely affect the outcome of his investigations. In his own words, he said, interference of witnesses is real. They are police officers, most of them to record statements. Most of those to record statements are their informers. They are now cooperating when that's the four suspects, are in custody. He was thoroughly cross-examined. He remained adamant that the four are capable of intimidating witnesses. They are highly trained and skilled in firearms. He confirmed that the suspect will have no role in the ballistics examination. Neither would they hinder post-mortem examination. He fears that the missing driver may be intimidated to come forth if the four are released. Mr. Omari submitted at length in opposition to the application. He has urged the court to admit the four to bond. He has said in lengthy submissions that the court ought to uphold the constitutional threshold on bond, that bond is a guaranteed right unless there are compelling reasons. He has also asked the court to uphold rights of the suspects to be deemed innocent unless the contrary is established in proof. He visited the ground for interference with witnesses. He said that the state needed to show that the four suspects actually attempted to interfere. Interference in and of itself, he said, is a crime. He considered the gist of the application as mere apprehension. In MA versus Republic, I have quoted, the investigating officer was apprehensive that the accused person was admitted to bond and to mingle amongst the deceased siblings and neighbors. He was likely to instill fear, cause trauma and mental anguish on them. Right to bail pending trial is not absolute. Bail can be denied if there are compelling reasons to warrant denial of bail, and that is the gist of Article 49H1H of the Constitution, which provides that an arrested person has the right to be released on bond or bail or on reasonable conditions pending a charge or trial unless there are compelling reasons not to be released. Further, under Article 52 of the Constitution, every accused person is entitled to the presumption of innocence. That duty lies on the prosecutions to demonstrate compelling reasons justifying denial of bail. Determining compelling reasons is a matter for judicial discretion. In Republic versus Munir Harun Ismail and four others, Warsame J is stated as follows: in deciding whether or not to grant bail, the basic factor or denominator is to secure the attendance of the accused person to answer the charges brought against him. The court has to take into consideration various factors and circumstances, and one paramount consideration is whether the release of the individual will endanger public safety, and the overall interest of the wider public. The bail and bond guidelines prescribe the following issues to be considered in grant of bail or bond. I have listed 12 of them. I think one of them is the one that is critical here, is quoted amongst them. All these considerations are meant to answer to the determination of the constitutional threshold. Is there any compelling reason not to grant bond? With the advent of the new constitution, there was a bit of confusion respecting Article 49(1)(h), and Justice Ibrahim, then serving in Mombasa High Court, held as follows. However, the law changed with the promulgation of the new Constitution of Kenya on 27th August 2010. Under the provisions of Article 49, it is now possible for an accused on a murder charge to apply for and be released on bail or bond. That is in the case of Republic versus Danson Mugunya and another. It's a celebrated case. He found that an arrested person has the right to be released on bond or bail on reasonable conditions pending a charge or trial. Now, I don't need to get into this. There are no specific guidelines governing the procedure for evaluation of bail application and the criteria to be used. However, Section 123 of the Criminal Procedure Code, Chapter 75 of the Laws of Kenya stipulates that subject to Article 49(h) of the Constitution and notwithstanding Section 123, in making a decision on bail and bond, the court shall have regard to the relevant circumstances and in particular, the nature or seriousness of the offense, the character antecedents, associations, and community ties of the accused person, the defendant's record in respect of the fulfillment of obligations under previous grants of bail and bond, and the strength of the evidence. So there are a few things I wish to highlight of my own experience with respect to bail and bond. Bail is a constitutional guarantee for any person charged with any offense. The foundation of any criminal trial where an accused person has pleaded not guilty and denied the charges is that he is presumed innocent until or otherwise proved. This presumption of innocence cannot be ousted, and the denial of bail or the grant of prohibited bail and bond terms may be a negation of this presumption. The grant of bail should be an automatic process unless an objection has been made for which the accused person will be required to respond why such an order to admit the accused person to bail or bond should not be made. These objections, in my experience, will take the form of evidence-based information demonstrating compelling reasons as required in the Constitution. Although the Constitution did not define the compelling reasons, the contours on the definition of compelling reasons are now becoming more clearer, and in case law has been held to include the following: that the accused person is a flight risk and would likely to not attend court whenever so required, that the accused person is likely to interfere with witnesses. And this is in the case of Republic versus Joktan Maende, another celebrated case by Honorable Justice Gikonyo, which elucidated the instances where interference with witnesses would constitute a compelling reason and how courts would adopt measures to curtail the grant of bail or bond founded on this ground. There are guiding principles that ought to be followed whenever faced with an objection to the grant of bail or bond on this ground, and Justice Gikonyo stated, where there is evidence that the accused person is accosted physically or otherwise by an accused person, that a person is accosted physically or otherwise by an accused person in the case where the person is a witness, it suffices to prove that the accused person did act standing or intended to interfere. In other words, you're speaking about evidence-based. So the accused person is likely to interfere with investigations by tampering with the evidence or compromise the integrity of the evidence, and in some instances, it has been argued that it is in the accused person's best interest not to grant bail. In our case, the ground enunciated by Corporal Orwa, that has been elucidated, is that the four are likely to interfere with the ongoing investigations and also interfere with witnesses. Here, daily basis, it has been challenged. The four at this stage remain suspects. They are not accused of any offense, at least not yet. Corporal Orwa is saying that by the time he came to the scene, he found that the scene had been manipulated and choreographed to appear as if the deceased shot himself with his own firearm. Corporal Orwa is also saying that the four could be linked to the robbery and hijacking of the lorry. At this stage, these are all matters under investigations. What is certain is that there is a police officer whose life is lost. There is also a missing driver of the lorry. It is said that there are witnesses who have now become comfortable to come forth when the four are in custody. They are not mere mortals. They are police officers. In Ahmed, Mohammed, Omar, and 6 others, Ochieng J, as he then was, and may his soul rest in peace, relied on the following quotation from the above case of Faris CJ in Rex versus Hawken. It is not a case from our jurisdiction. The question of bail is sometimes misunderstood. When a man is accused, he is nevertheless still presumed to be innocent, and the object of keeping him in custody prior to trial is not on the theory that he is guilty, but on the necessity of having him available for trial. It is proper that bail should be granted when the judge is satisfied that the bail will ensure the accused appearing at his trial. So the investigating officer and the prosecution have cited possible interference as a primary concern for demanding the accused persons be held in custody. In the case of Republic versus Joktan Maende that I have cited, the issue when the seriousness with which the court should consider the question of possible interference with witnesses was addressed by Justice Gikonyo. Not to the Gikonyo, but Justice Gikonyo J in the following words. All that the law requires is that there is interference in the sense of influencing or compromising or inducing or terrifying or doing such other acts to a witness with the aim that the witness will not give evidence or will give particular evidence or in a particular manner. Interference with witnesses covers a wide range. It can be immediately on commission of the offense, during investigations, at inception of the criminal charge in court, or during the trial, and can be committed by any person, including the accused, witnesses, or other persons. The descriptors of the kind of acts which amount to interference with witnesses are varied and numerous, but it is the court which decides in the circumstances of each case if the interference is aimed at impeding or perverting the course of justice, and if it is so found, it is a justifiable reason to limit the right to liberty of the accused. In all civilized systems of court, interference with witnesses is a highly potent ground on which the accused may be refused bail. It is a reasonable and justifiable limitation of right to liberty in law in an open and democratic society as a way of safeguarding administration of justice. Undoubtedly, a cardinal tenet in criminal justice, social justice, and the rule of law in general as envisioned by the people of Kenya in the preamble to the Constitution of Kenya 2010. In the case of Republic versus David Ochieng Ajwang alias Daudi and 11 others, Sitati J again pronounced herself on this issue. In my view, the above fears are not mere whims on the part of the prosecution. I am persuaded that because of the volatility of the situation on the ground, the temptation to jump bail is heightened to such an extent that this court cannot overlook it. It is not in dispute that all the accused persons hail from the same locality as the potential witnesses, and this being the case, the danger of such witnesses being driven into a corner by the presence of the accused person so soon after the ghastly death of the deceased person is a real possibility. In addition, the fact that the accused person are so many is likely to send a cold shiver down the spines of such witnesses and corner them into resigning not to appear in court during the hearing of the case, even if the accused persons turn up. In a nutshell, there will be no witnesses to testify. And she quoted Makhandia J in Kiteme Maangi, where he said, murder is a serious offense and attracts the death penalty. Self-preservation is a natural reaction or response of any human being. That self-preservation may take the form of ensuring critical evidence is suppressed forever, or the applicant himself takes flight. Finally, such potential witnesses may not be comfortable seeing the accused walk around, knowing that their evidence is critical to the success of the prosecution's case. That is reason enough to cause such witnesses to have genuine fear, misapprehension, and anxiety. It may even lead to such witnesses refusing to testify due to genuine misapprehension of their safety. Just like in the Willie Kimani case, this is the case of Republic versus Frederick Oleleliman and 4 others. The accused persons herein are police officers. They are the gatekeepers of law and order. It is a duty some pay the ultimate price to perform and defend. In their bond application, the accused persons in the Willie Kimani case were denied bond. The court observed the role of undermining the criminal justice system as a key ingredient and component. Justice Lesit had this to say: undermining the criminal justice system includes instances where there is a likelihood that witnesses may be interfered with or intimidated. The likelihood that accused may interfere with the evidence or may endanger an individual or individuals or the public at large. Likelihood that the accused may commit other offenses. In these instances, where such interferences may occur, the court has to determine whether the integrity of the criminal process and the evidence may be preserved by attaching stringent terms to the bond or bail terms, or whether they may not be guaranteed, in which case the court may find that it is necessary to subject the accused to pre-trial detention. She further observed, in this case the drama was when the matter was presented before Kimaru J, and the fact that at the very start of investigations in that case, it was clear to the judge the risks potential witnesses in this case faced, behooving upon the judge to give certain directions in their regard, are all very telling. Given the facts presented before the court when considering this application that the first and second deceased were actually leaving the court after hearing of the case involving the second deceased hearing, the first accused, it would appear that the attack on the deceased was intended to interfere with the trial before the court. There are parallels to be drawn in the instance case and that of Willie Kimani. The suspects here are all police officers. Their colleague has been killed and he died in their company ostensibly to enforce the law. They are now prime suspects to his murder. Even more, they are suspected of having something to do with the hijacking of the motor vehicle. The witnesses are likely the same people who were his past. The investigator says he has homed in on the loaders. They are now cooperating because the 4 are ill. The 4 are not your ordinary mortals. They are law enforcers, well-trained, I suppose, and highly skilled. As has been observed, with self-preservation knocking, the chances of interference with witnesses become highly likely. Justice Lesit further observed, It has been shown through the various dispositions filed in opposition to bail that the potential witnesses in this case come from the same area as the applicants. It is not disputed by the defense that the accused person hailed from the same locality as the potential witnesses, and this being the case, the danger of such witnesses being driven into a corner by the presence of the accused person so soon after the ghastly death of the deceased person is a real possibility. She made her finding. Thus, in this case, I have come to the conclusion that there exist strong, compelling reasons why the applicant should not be released on bond. Stringent bond terms cannot guarantee safeguards to the integrity of the trial process, neither can it guarantee the progress of the case to finality. This is not an ordinary case. The defendants of the law are now prime suspects. One of them is a subject. He is deceased, murdered by suspected colleagues. I am prepared to err on the side of caution, so my disposition is that I am persuaded that the 4 suspects ought to be detained as prayed. I have also considered the period sought, and I find that the 21 days is unjustified. I will allow the investigator 10 days to conclude his investigations, and I now allow the application. The 4 suspects will be detained at Naivasha Police Station for a period of 10 days from today. The matter will be mentioned on 11th of November 2025 for further orders. It's not signed because it's electronically signed.
I understand.
Yes.
Much obliged, Your Honor.
Yes.
Thank you for the reasoned ruling. We have nothing to comment about it, but to say, wish you all the best.
Thank you.
In your interview that is coming.
Thank you. I'm sorry I went to the mosque, that's why I delayed.
I understand.
This is Friday, so I finished late, so maybe sorry for keeping you here, but I'm sure you can see why.
Much obliged.
All right. Nipatie wale watu wangu kina Ekal na wengine.